Good afternoon, everyone. So, uh, so the Carrie sir is not here, but he is joining online through video, and he is the founder of Instant IP and Igniting Souls. Carrie is a visionary leader who helps transform ideas into empires and set free world-changing ideas. He reframes IP not as a legal paperwork, but as economic infrastructure for creators, innovators, and digital economies. A best selling author, inventor, and thought leader, his work sits at the intersection of IP, entrepreneurship, blockchain, and transformational leadership. So, uh, so please join me in welcoming via video presence Carrie O'Brunner.
Hi, Legal Tech Meet. My name is Dr. Carrie Oberbrunner. I'd like to thank, first of all, Advocate Rajat Dutta. Hope my pronunciation is correct. I want to thank you sincerely for inviting me. I'm going to get right into the content. I wish I could be joining you. However, I'm a university professor and I'm teaching in the middle of the semester. But when I got the invite, I just want to say I immediately responded with an absolute yes. I've studied exactly what the conference is all about. I've seen the distinguished speakers. Congratulations for your geographic area saying yes to exploring this important topic. Because I only have 7 to 10 minutes, I may pause this just so I maximize the time. However, let's get right into it. In the United States, we have what I have termed the IP dam dilemma. What that means is that there is a huge bottleneck. There's way too much friction. We see this friction anytime someone has an idea and they want to protect something, they have a lot of friction. And we know that when there's friction in life, whether it's taxi drivers becoming Uber or the hospitality industry with Airbnb, anytime that there's a lot of friction for the consumer, disruption is sure to happen. I wrote this article back in April. It basically describes that there is a bottleneck. In the US, we have over 800,000 patents waiting to be processed. Trademarks, copyrights are not a better story. And I said to myself, there has to be a better way. We are now moving at the speed of thought. We now have AI on the rise. AI is not the enemy, but AI is sure to steal our intellectual property if we're not careful. I've had my own intellectual property stolen. One with my book back in 2010. I've written 14 different books, and Your Secret Name, one of my books, was absolutely stolen. But most recently, my TEDx was stolen. So imagine doing a TEDx on blockchain, which I'm going to share with you today, a little bit about that value proposition statement. But it has over 1 million views, and sure enough, as I was preparing for my book, You Are an IP Company, to come out, I realized with a quick search that someone had actually taken my exact talk and stolen it. And I posted this on LinkedIn about a year ago. Somebody stole my intellectual property. Has that ever happened to you? By the way, if that does happen to you, do a quick screenshot. That's exactly what I did. And you can see here that this gentleman named Sergi, who I did not know, from the country of Georgia, had basically scraped my entire TEDx talk. Here's what's interesting. This man is a gentleman because he said, I deeply apologize. I used AI to write articles, and I had no idea that it took your exact TEDx talk. I apologize, and please forgive me. I said, no problem, don't worry about it. But this begs the question that there's a lot of people unintentionally stealing intellectual property simply because AI is serving it up in posts. If you post anything, picture, video, article, if you have not put a fence around that through intellectual property protection, it's like somebody going into your house and stealing it. Sometimes intentionally, sometimes unintentionally. So what do? What's the solution? Let me go back to that word really quick, abracadabra. Abracadabra, does anyone know what it means? It means I create as I speak, or it came to pass as it was spoken. Think about that for a moment. I create as I speak. I believe that we need to protect as we imagine. I believe that we need to basically think of something and immediately put a fence around it through intellectual property protection. Patents, trademarks, copyrights, they do not offer a great solution. Why? Because it's time and money, time and money, time and money. In the US, the average patent rejection is 86% for a first-time filing, 86 to 88%. No one has this type of time and this type of money just to wait. So I said to myself a few years ago, there has to be a solution. It's called blockchain. Before we jump into the how, maybe we should talk about the why. Why protect intellectual property? Well, first of all, it is because if you look at the S&P 500, there is a major shift. In 1975, only 17% of the most valuable companies on the planet were IP. Now in 2020 and beyond, it's actually 90 to 96%. 90 to 96% of things like Apple, right? iPhone, things like Airbnb, any type of company, the 500 most valuable, 90 to 96% of the value of those companies are in an intellectual property. You might say, Kerry, I don't know if I have any intellectual property. You absolutely do. Here's a quick example of 45 different ways of IP, 45 different expressions. You can see here, websites, announcements, products, slide decks, publications, you name it. And in fact, we teach that your IP can actually be monetized in 47 different ways. This is all found in my book, You Are an IP Company. And in this book, we talk about 12 different steps on how to become an IP company. This is things like Taylor Swift. Taylor Swift is an IP company. Krispy Kreme donuts, you name it. Anytime you have differentiation, that is IP. So we've looked at the what is IP, 45 different expressions. Why protect IP? Because it's valuable. But here's what I want to share before I demo it. If you don't take your IP seriously, other people won't take you seriously. So what do I mean by that? I'm basically saying that imagine if you don't care about your IP, what if somebody else cares about it, your competitor, protects it, and locks you out of your own ideas and invention? This is very possible. And that's why we have to put a protection around our intellectual property. I call this a fence. You might not need the huge fence like the Great Wall of China, like a patent, but blockchain offers a fence that people respect. Why? Because it's time-stamped. And all intellectual property is based on time. You were there first, and that's why it's your invention. In fact, there's a term called prior art in patent law, which basically says that if you have proof that you were there first, the patent is no longer new and novel. So basically, if you protect something with instant IP, if someone comes along later and says, hey, that's mine, you actually can take down their patent because you were there first. They have proof that you have prior art. So let's demo Instant IP, which is my second company. And that is what I'm deeply passionate about. I'm deeply passionate about giving enterprises, businesses, creators protection so that they can keep protecting their IP and keep creating. I call this the IP flywheel. Everybody has products and services. And if you are going to publish that and then promote it without protecting, you now leave yourself vulnerable. This produces clarity, confidence, credibility, and capital. You must publish, but you have to protect, and then you promote, then you profit. Everybody here can try this for free. It's instantip.app. It's not in the App Store on purpose. We don't want anyone or anything getting between you and your IP. You can access this on a computer, a phone, a tablet. All you do is you create an account, and you can upload up to 100 megabytes, photo, text, file, you name it. I'm going to protect something like, for example, my logo. Why? Because let's say I come up with this and I want to protect it immediately. I name it and I describe it. I'm just going to put in the word test just to show you as an example. You can hide it and keep it as a trade secret, or you can go public. This is defense, this is offense. I'm going to keep mine just hidden so that you can see the example. When I click protect my idea, I use a credit. Everybody starts out with 1 credit for free. When I hit submit, it verifies it, it uses the IP credit, it turns it into a smart contract, it timestamps it. It's immutable, meaning that you can never change it, not even me. And now it's protected. I can view it in my portal, and now, my friend, I can transfer that asset. I can literally transfer that asset at a sale event or an exit of a company. I can share it, I can download it. I even have a certificate in case somebody tries to infringe. I now have a cease and desist letter with a timestamp on the blockchain. We use this with Polygon layer 2 Ethereum, and I can view that. It turns it into an asset, it timestamps it, and now I can go back and prove that I was there first. Folks, I wish I could share more with you, but let me just share this in general. Why be passionate about IP? Because we are humans. Humans are different than AI. AI is fine, it's a tool, but it can never replace humans. However, if we abdicate our responsibility of IP creation to AI, in my opinion, it is the downfall of humanity. We must beef up our confidence, and the way that we do that is through IP protection that is simple, fast, and as we say with Instant IP, it literally is idea protection at the speed of thought. This is Kerry Oberbrunner. Please reach out if you need anything. I'm here to serve. I'm here to help. I love to form collaborations with you. Let's take this idea to the masses. And the cool news about this is we have multiple patents around this. Again, I'm not against patents at all. I'm passionate about it, but we need a solution that is no longer the old archaic way. We no longer ride horses and buggies in modern civilization. We use cars. It is time for a new technology to come alongside traditional ways of IP protection. Thanks for having me.
So, I really thank Dr. Carey for this wonderful video presentation and his abracadabra philosophy for protecting the IP data by means of stamped based data and the blockchain. So your IP will be protected on each and every node, and the timestamp data is also available, and you can also send the infringement notices to someone who is going to infringe your IP if suppose he invent it after you. That is a great thing. Let's see how it will again evolve as the blockchain and the other things are evolving. So I would like to ask one question to our panelist, Dr. Sriram sir, regarding this. So before that, I would like to ask to Utsav sir, like Carey talks about turning IP into multiple revenue streams, right? From a legal and strategic standpoint, where do you see founders struggle most when they try to commercialize IP globally?
Well, so the thing here is that before you commercialize your IP anywhere, you ideally should have it registered in that country. Because see, we have now, even before patents, what is the first kind of IP that anybody gets? It's a trademark, right? So a trademark also is not filed the same way or enforced the same way in every country. Like there are two kinds of jurisdictions. There is first to file and there's first to use. So our country, India, is actually first to use jurisdiction, which means that prior user, the person or the company is using that trademark first, has priority over the person who files first. But there are many jurisdictions in the world, like say for example, I can think of Thailand and the countries in the Middle East. They are all first to file jurisdictions. So now, before you commercialize your IP, before you license it, before you make revenue from it, you need to know that your licensee will not altogether usurp your IP. And in order to do that, you need to have your IP protected in the country where you're licensing it out. So say for example, you're licensing out your IP in Kuwait, like we help somebody file a trademark in Kuwait. So first of all, we did a trademark search. And even before we filed, from the search that we conducted for this client, it came out that almost same kind of trademark with the same name, very similar logo was already there. So before he gets to that grand vision of commercializing, he needs to know whether it's possible in that particular jurisdiction or not. Don't take it that he can't commercialize it if it's already registered, but he will need to amend his trademark, maybe make a variant of it before filing it there. So this is a practical challenge. Then of course in the online world you have a lot of counterfeiting. Counterfeiters, they use fake names, they use fake credentials and IDs. So it's very difficult to track them down. So internationally, if you're licensing your IP, that is another challenge. So yeah, that's my answer to the question.
Hello. Thank you, sir, for your answer. And I have another question to Dr. Sriram, sir. So, as a carries vision assumes that IP rights can be effectively enforced. From what you see in digital marketplaces, where does that vision collide with enforcement realities on platforms?
Thank you, Gauri. Yeah, so as Carrie said that IP rights are enforceable, yes, I completely agree with him. Now let's answer this question from the perspective of a digital marketplace. I think that to answer that question from this perspective, the answer needs a slight modification. Because the digital marketplace, as I believe, is a completely different animal, and to enforce your IP rights on in the digital world is a completely different ball game. So it was not like you are going after a physical, you're going into the physical marketplace and identifying an infringer or the source of the infringing products by way of an investigation. It's still easier comparatively. In the digital marketplace, it is such a big ocean that you do not know most of the times you don't know where the source is. There are so many URLs, there are so many listings, algorithms that are being used. Technology, as much as it is being used to identify where the source of infringement is or where the infringers are, it is also helping the it is also infringing the infringers likewise. So there is not one single bad actor. Sometimes you don't even know where these people are sitting. So yes, so if you want to enforce your intellectual property in the digital marketplace, it requires that extra diligence, the extra steps that you need to take to ensure that there is no recurrence of infringement. And technology, of course, platforms and the digital marketplace does help you out with all these things. But then the brand owners and the lawyers also need to be completely aware of not just the procedures, but a harsh reality and a harsh reality which says that you cannot stop after one action. You cannot just fill up a form and then stop. You need to be extremely vigilant about recurrence and the same products coming back into the digital marketplace by the same actors or by someone else. So the entire ecosystem of enforcing intellectual property on a digital marketplace, to come back to the question, Gauri, yes, you can enforce it, but then it requires that those extra steps in vigilance from your side.
So yeah, definitely, as everyone want to sell their products, services on e-commerce, and the duplicate products are easily available on the e-commerce, and the tracking of data is very, very hard. Sometimes it will track, we can send infringement notice to someone, but at the same time the other peoples are doing the same task. So how many infringement notice someone can send to someone doing these kind of things? So definitely this is the issue. Timestamp based data need to be tracked properly. That is another thing. So I have another question to both of you. Is there a gap today between how innovators want to use IP commercially and what the law performs realistically allow to do that? Yeah.
Sure. So, see, when we talk about the gaps in law or practical implementation of, say, commercialization of IP, one thing that people struggle with, I think, is proper licensing, right? So, I already talked about registration, that is separate. Now, we come to licensing. Now, once you have your mark registered, now if you want to commercialize it, you want to make money from it, you basically give a license to a third party, and that licensee pays you a certain royalty or a fee for use of that IP. Now, what happens in this process is that it's not that straightforward. You have to negotiate the terms, irrespective of whether you're the licensor or you're the licensee. The terms have to be negotiated very carefully in the agreement, in the licensing agreement or the transfer deed. Transfer is actually different, but licensing agreement, let's say, because those terms need to be very clear that the ownership of the IP will be retained with the original owner, and the licensee will only have so much of a right to use And there need to be very clear terms, because especially when you're talking about licensing between different countries. So if those terms are not clear, it's very easy for the licensor to eventually relinquish their own IP, right? So that is one challenge in practical implementation. And for the licensee also, they need to negotiate the terms in such a manner that they're able to effectively actually brand using that IP, whether they're running a franchisee or some other kind of branch of that licensor, that, you know, without taking over ownership of the IP, even just as a licensee, they're able to effectively actually brand and do business with that IP. So this is a challenge in practical implementation.
Yeah, definitely. So I have one follow-up question to Sriram sir. If IP is becoming a business asset rather than just a legal right, should founders rethink how early they invest in enforcement and compliance? How early the founders will think to invest in the enforcement and compliance?
Well, to tweak your question a little bit, if you, the one aspect is how early should the founders invest in compliance, and and in reality, how seriously are the founders taking this? So, yes, IP is a very serious business, and the founders should take it up very, very seriously and invest in this compliance at a very, very early stage. Obviously, once they are very, very sure about what they want to use as an IP, say for example as a trademark. So even to look for a trademark, even to come zero in on a decision on which trademark they want to adopt for their business, either as a trade name or a brand name for their product or for their service, there is a certain amount of investment in terms of time and money that they should consider. Some of the mistakes that founders, at least the early stage founders, are making is that they probably want to avoid these steps to cost cut. But then that's not advisable. The founder should, it is like spending 100 rupees to save 10,000 rupees in the future. So it's a part of your diligence. It's a safety net that you build around your business to ensure that you are adopting the right kind of IP and you're working your business around the correct IP. So yes, the founder should invest at an early stage, and they should invest time also before they come down to a decision on what they want to start using.
That is, I also want to share one case study which I have done, that I'm working with one of the startup, IIT based startup, and the founders are well known, they are not known about the IP, they well known about the technology, they are very good in making technology, they are purely technocrats, even they know that their market is going to sell in the market, and it is a very good startup, but as due to they are not protecting it in a proper way, they are not making like they don't aware about patent, also SICLD, because it is a medtech, and due to some founders conflict, the founding team know the technology, also the founder and co-founder both knows the technology, and due to the conflict and due to the not setting the agreements on the right time, not filing the IP on the right time, the issue is worsened a lot. And definitely the time is very important to consider while you are starting any startups, and also how we can protect our IP and in which domain you need to protect what. It need to be evaluated properly, and the help of legal people and patent agents is very important in this scenario. Also incubators need to intervene in this and help the startups to help them to file their IP on the right time, to avoid the other things like founders conflict or the other things, right? So definitely another question is for the Sriram sir regarding the platforms only, and let's see. We often hear that platforms are protected as intermediaries. From what you have seen in courts, is the real question today is less about labels and about more about the conduct, right? So what do you think about it?
Yeah, if I have to give a one-word answer to what Gauri just asked, yes, it is more about the conduct. And there are two aspects to this. Now, platforms have certain grievance mechanisms, like they have certain copyright grievance forms, trademarks for domain names, etc. So where infringing and counterfeit products can be identified, and the brand owner or their lawyer should go and take those steps and fill up those forms. One is the grievance mechanism and the existence of that mechanism in itself. The second issue is the conduct of the platform once those steps are taken diligently by the plaintiff. Now, courts are very, very seriously considering and looking into the conduct of the platforms post notice or post the action is taken. And it is not just the existence of a grievance mechanism which is very, very relevant in today's day and age. Now, just to take an example, Amazon, for example, has one of the it has the gold star of grievance mechanisms. But in one of the decisions, for Amazon to be labeled as an intermediary, it was unable to prove that it is a mere intermediary, and the safe harbor defense was not available to Amazon, despite having one of the best grievance mechanisms. So, because the courts are now looking into what is the action the intermediary is taking. Has the intermediary actively participated in the infringement? Has it facilitated the commercial transactions? Has it, despite being made aware, been very, very passive about this whole thing? So these are the issues that the court is taking. In fact, it's not the evolution of technology itself which is bothering the court. So, for example, very, very recently, the Delhi High Court also in a couple of decisions directed the domain name registrar, which is the National Internet Exchange of India, to cross-check KYC details of the domain name registrant who was actually applying for an infringing domain name. So that is the extent to which the courts are going. So, and there's another decision, which is a very landmark decision which involves India Mart. So India Mart does not really have one of the best grievance mechanisms, but it has a very, it is not even very IP specific, if I am not mistaken. But then it has a very general procedure which any aggrieved person can follow and bring it to the attention. But India Mart's conduct was so prompt, post notice and post being brought to attention about the infringing products, the plaintiff was Puma in that the court gave India Mart the benefit of safe harbor under the Information Technology Act. So it is the conduct of the intermediary, it is the conduct of the platform which weighs heavier than the actual existence of the grievance mechanism or what are the procedures that a brand follows before approaching the court.
So, if the intermediaries are taking this kind of precautions that the counterfeit goods cannot be sold on their platform, and if they incorporate some more advanced tech to verify it whether it is coming from the right source or not, definitely it is very important. Sometimes the platforms are worked as a neutral platforms, and in that scenario, what is your thoughts, sir?
See, neutrality is a defense. Neutrality is not a permanent status. Okay, you cannot stick to that forever. So, if I have to answer your question in just three lines, I will say the first instance at which you are informed about the infringement, staying silent at the first instance may be passed off as ignorance. The second instance, yes, you can say it is a delay. And the third instance, I would rather say it that then the courts will definitely step up and say, you are not just the road. You are now allowing rash driving on the road. So it's to put it in from a traffic perspective, because since we are sitting in Bangalore, and which is notorious for its road and traffic situations. So I said that it's not just it's not a permanent status, then you can sit around and say that, okay, I am neutral and I am not allowing it. You have been informed about it. You are now aware of it. All the necessary procedures have been followed. And after that, what are you doing? Is what the courts are going to definitely ask the intermediaries. And now the intermediaries cannot anymore take the defense that they are or take the benefit of Section 79 of the Information Technology Act, which talks about safe harbor. Just to give you another example, there are two decisions most of the people here will be aware of, which involves Google. One is one of Madras High Court, which was passed in 2013. Another is just 10 years, fast forward to 10 years, 2023, was passed by the Delhi High Court. At that point of time, way back in 2013, Google was able to prove that it is an intermediary because it was not actively involved in the infringement. It was not actively, it did not facilitate any of those things. Now, by the time a similar situation came up before the court in 2023, amongst like inter alia, various other factors, the court was also more attuned to the technology and the developments around it. But at that point of time, this is both the cases were related to keyword advertising. So by that time, the court was more confident, and it in fact, Google was not given the safe harbor. So with the evolution of time, evolution of technology, and with the benefit of technology, which both the plaintiff and the defendant, both of them have, it is becoming more and more difficult for platforms to say that no, I am not involved in this and I am just an intermediary. Yeah.
So in case of Google Ads, suppose Google Ads is incorporating some keywords which are having trademarks. And in that scenario, what you suggest, whether the Information Technology Act will prevail?
Not necessary. Like as I said, it entirely depends on the conduct of Google in that. It entirely depends on how much Google has facilitated. Because when an infringer, or say for let's not call him an infringer, when a defendant wants to use a certain brand as a keyword for his own advertisement, it will definitely apply with Google. So what are the safety measures that Google is taking to ensure that this is not an infringing brand? What are the safety measures that Google is taking to, after being, okay fine, but after Google is being told that this is infringement, what are the steps that Google has taken will be considered by the court to facilitate the argument and to give the benefit of being an intermediary to Google. Or for that example, any search engine, why just Google?
Yeah, sure. So I have few of the connects, and I know that there are few startups which are helping to track the trademark infringement through URLs. Okay, so whether going to these kind of startups will like enhance your search, trademark infringement search, and reduce your time, what you suggest?
See, there are two ways of looking at it. Are these startups identifying in general which are the trademarks that are infringing to your trademarks? Or are these startups, if you are giving a certain, if you are bringing a certain URL or an infringing activity to the startup's attention, or say for example this particular service provider, if you are bringing it to their attention, are they helping you in identifying the source of that? Yeah. So I would say that I would say that I'm pretty sure that if these kind of, like for example, as far as I am aware, Amazon, Google, Flipkart, or even Meesho's and all these online platforms, they have their own IP grievance mechanisms. So when you go to these, when you use these IP grievance mechanisms, they are good enough for you to sort of bring it to the attention of these platforms. But if these kind of startups are coming up and if they are facilitating the identification of infringement, so to say, I am pretty sure that in due course they will also be a part of these, you know, they're the, whatever they have unearthed or whatever they have found out will be forming, will be evidence in the litigation. So I'm pretty sure that the authenticity of that evidence will definitely, you know, it will show up whether the courts are actually taking them seriously. So in due course, I would suggest that yes, I mean, there's no harm in using their services. But then one should also be vigilant about which ones are authentic, which ones are really helpful, and which are the ones who understand this whole ecosystem of infringement on digital, this thing, in the digital world.
I have the last one question for you. We are now dealing with AI generated content, algorithmic discovery, and domain abuse. Are courts really treating these as a new problems?
I don't think so, because this is a different technology. AI is a different technology as compared to an e-commerce platform. But are the courts dealing this in a different way? By and large, no, because at the end of the day, courts are only going to look into the fact that whether it is an infringement or not. Courts are again going to examine whether the conduct of the intermediary is relevant or not in this particular case. So yes, like for example, AI generates information and content at industrial speed. So the manner in which the infringement will be facilitated will be much faster. It will be much faster. So it will be more prudent upon the brand owners or the plaintiffs to be more vigilant about how these infringements are happening on the AI platforms as compared to the digital, the e-commerce platforms. So definitely the manner in which the brands will have to be, look into this issue, and how they will facilitate this entire ecosystem of identifying the URLs and identifying the product and the source or the bad actor behind this is definitely going to be it's going to be a tougher challenge. But courts more or less are not going to look into these things as much as the brand owners will. And at the end of the day, the same technology which is helping the brand owners identifying is also helping the infringers in creating more and more infringing content. So deep tech or legal tech or technology is cutting across both ways. So it's not going to be easy. But when it comes down to the court is only going to ask a few questions. The same old questions I think the court is going to ask. Who is the infringer? What are the steps the plaintiff has taken to identify the infringer? Which are the URLs? Where is the source? And what has been the conduct of the AI tool or the AI platform after it was made aware of what exactly is happening?
Yeah, definitely. As we are evolving in this space, the new policies will definitely come, the new reforms will come, and we need to rethink on how the judgment need to be based on, as there are also non-traditional trademarks, and there are a lot of things are going on in very less time. So I have another question to Utsav, as Utsav is handling so many cases regarding counterfeit goods. So Utsav, this is for you. So counterfeit goods on a major e-commerce platform where the focus wasn't just takedown but systemic safeguards. How did the experience change the way you view IP enforcement in digital economy?
Right, Gauri. So I think you're referring basically to a case which I was in which basically we had filed a lawsuit against a very major e-commerce platform for allowing the sale of counterfeits of pharmaceutical products. That was this case. So I think how this impacted me is that we got a very different kind of order in this case, right? So what we got was that not only was the platform obligated to take down within 24 hours of every time that we reported the listings to them, they were also directed by the court to put in place certain safeguards, right? To put in place certain safeguards to at least identify counterfeiters or try their best, because see, in reality it's not very easy. Like I mentioned earlier, counterfeiters constantly change their names, their GST numbers, their identity. But the safeguards need to be put in place where when you are seeing a repeated counterfeit sale of a certain type of product, so at least you should have some check and balance, right? So your question being also that how this affected my outlook on these kind, on how this kind of jurisprudence should evolve. So my outlook definitely in this respect has changed, that something similar to what my co-panelist has said, not very different. That it's not only about that whether you are an intermediary or not, right? Like even an AI platform can contain today, like we saw Mr. Dr. Carey right now on the video, he was speaking and he was saying that the AI took his content and they basically facilitated that infringement, right? And now the AI is going to say that, oh, I am also just an intermediary, I am just a platform, and the content I just sifts through me and I am not responsible for what's being churned out. But we cannot keep on playing that same cassette again and again. We have seen case laws in India also, where there were advertisements of prenatal sex determination on certain platforms, there was availability of pornography. So over there the courts held very strict views even long back in the day, and they said that you need to have the right kind of measures in place. When you're profiting from this, you're heavily profiting from this and it's happening, you cannot just turn a blind eye. And law is meant to be read in the context of the facts of each case. We can't just read section 79 of the IT Act, like my co-panelist also said, and say that it's just that you're an intermediary and you're exempted from liability. It's not a blanket,
Yeah,
escape.
definitely. Yes,
That's
yes.
my outlook.
Yeah, definitely. So that is a great discussion regarding this. So I have another question regarding the business asset, IP as a business asset. So you have noted that IP is no longer just a legal formality, but a business asset. From your experience, what does it actually mean to take IP seriously as a business today? Is this shift more relevant now because of AI and tech-led businesses?
So yes, definitely we are seeing a shift across the world in how seriously IP is being taken, because today with enhanced digitization, it's very easy to catch infringement online. So every brand, small or big, and we are now a brand-oriented economy, right? Everyone today is identifying brands, and So in order to take your IP seriously, first of all you need to have it registered across jurisdictions, because if you're planning on globalizing, the sooner that you register your IP across countries, across different continents, your IP will be taken seriously globally. And there is a concept of global IP recognition even before Indian courts. So there's a very famous case of Viagra before the Delhi High Court, where the Delhi High Court held that even though Viagra, there was another smaller brand called Viagra, but they upheld the rights of the well-known Viagra brand across the world, because that had a global recognition, which basically was far greater than this other brand, which was although had prior usage. So basically they went against prior usage and they upheld instead of that global recognition. So that is very important. And then also optimization of your IP, commercialization. What I have noticed is that there's less commercialization of IP in India. You could make a lot of money from your IP, royalties, licensing. But more of that happens, I see, in states like Maharashtra, Mumbai, where you have the music and the film industry. Whereas in Delhi, NCR, other prime areas of India, there's still very less licensing of IP. Even Southeast Asia, where I spent much of my life, and the Middle East I have seen, where there's a lot of IP licensing revenue. Of course, in the West, there's a lot of IP licensing revenue. So these two things. And the third, enforcement. Even enforcement is a good way of leveraging your IP. So when you send somebody a takedown notice, when if necessary, even if you file a lawsuit and you get an injunction, because injunctions are granted very quickly, at least in Delhi. So there you enhance the value of your brand, right? You're making your brand even stronger by not letting people misuse your IP. Now this doesn't mean that restrict competition, but not letting them misuse.
So in few of your interviews and few of your videos, you are talking about trademark squatting. So, how we can prevent the trademark squatting in the era of AI?
So trademark squatting and domain name squatting, these are two things that go hand in hand. Domain name squatting is a common practice where people they apply and register a domain name without any intention of using it. Now why do they do this? They do similar things for trademarks. They, whenever a genuine user will now come forward to use that particular name or something similar, this squatter will charge a handsome sum of money and make revenue from this. And the thing is that many people don't know that this is actually not legal in India and in many countries. It's not really legal because there are judgments which have held that trademark and domain name squatting is unlawful. So, that definitely, we ourselves sent a legal notice to a squatter in a domain name case, and quickly there was a settlement. And if you know the law about this, if you enforce your legal rights properly, so a domain name or a trademark squatter will not be able to make unfair revenue, from the trademark or domain name that actually should be yours, because you are a genuine user, right? You actually want to use that in business.
So the last question. So in the recent newspaper article, you talked about the grant of smell mark, and you told that it should come under patents, not trademarks. So I would like to understand why you are telling that it should not come under non-conventional trademark as a smell mark. Instead of that, it can come under the patents.
Right, Gauri. So you're referring to the recent smell trademark that has been granted in India very recently to Sumimoto for rose-scented tires. So this is very interesting. This is the first of its kind in India. And here what they have said is that this is a source identifier, that people will identify our cars, our tires actually, because of the rose smell. So over here, what I have pointed out is that, and so I've given this in one business law journal, a quote, that they actually presented a diagram to the trademark registry, and they said that we have applied so and so, technical, say, formulations or methods and chemical compounds to make this smell. So to my mind, and please anybody correct me if I'm wrong, this is just an opinion, but I think this could be classified as a patent, because over here you have created something, right? You have created the scent through the use of compounds, and now you are trying to register it, right? So just because it's a source identifier, it can't be a trademark. In my opinion, it should be a patent. And the other thing I've said is, if it's neither of the two, then you bring about new laws to recognize unconventional and new forms of IP like personality rights, smell marks, sonic marks, and so and so.
Yeah, definitely. So if audience have any questions, they can ask. Yeah.
Yeah, thanks panel for the interesting session, and thanks Rajat and the organizing committee for getting so much of diverse speakers list today. It's really interesting in the first half. So brief background about me, I'm by profession an engineer. I'm currently working at Qualcomm and been working in embedded systems. But I also have a degree in law and specialization in IPR. So my question, because I usually interact with startup founders and new entrepreneurs. So a lot of people who are technocrats, like you've covered in this panel, and we also know about these IP stack, not just patents, but IP stack in the earlier plenary session that we had. Is that it's not just patents or trademarks, but you have end user license agreements or data privacy and all of these things when you're launching an app or any of these things. And the founders are essentially do not care about these things in the initial stages because of the cost cutting, as you mentioned, or because they don't have the time for it, because survivability is key and not protection at the moment. So at this stage, and especially in India, when the founders are not really aware of the existing laws and how to protect their IP, and leave alone protecting, but how to identify the IP is a big question for them. So at what stage do they need to start protecting their IP? Is it when they get the proof of concept, or is it when they find the co-founder, or is it when they get the first series of funding? At what stage should they start protecting their IP? And my second question is, if they do want to, quickly validate if their idea qualifies to become intellectual property, like what we've seen instant IP right now. That's one good platform. But for more serious, technically strong ideas, which can be patented. But for now, maybe patent is the long way to go. So maybe they want to just protect their idea. They want to quickly validate if their idea qualifies to be, an IP. So what can new founders take steps to identify this? Yeah. My question is to Sriram, by the way. Yeah.
Hi. I think to answer your question on when should they start protecting their IP, it is as soon as they are aware of what they want to protect. So they should not delay it any further. Because again, whether they want to protect it in India or they want to protect it abroad. And as already Utsav has mentioned, there are various countries which are first to file jurisdictions. There are some countries which are first to use jurisdiction. Even the countries where for example, India, which is first to use, it is still advisable to immediately file. Talking strictly from a trademark perspective, if I have to say, they should immediately file an application for their trademark, irrespective of how long ever it may take to get registered, because at least they are in the queue. And they should know that irrespective of the fact that they are using it first, before another person starts using it, or before another person may have filed it, the law is still in their favor. But irrespective of that, that registration certificate is a weapon in that person's hand to tomorrow attack an infringer. So it's that additional benefit. So my answer, very simple answer, is that they should immediately do it. Now, if they are worried about costs, I think the government itself has come up with a lot of schemes for startups, and there are a lot of, I think they need to be guided more on, they need to be made aware of how to go about this. So once they are made aware of how to go about this, government has a lot of schemes, and we as a lawyers community also can take those initiatives to guide the startups and to make them aware of not just the procedures, but also the importance of doing it at a very early stage. So that's it.
Thank you.
So another last question here.
Thank you so much for this fascinating panel. My name is Marcy Foucard from France, and I represent the French delegation. And I work in a legal tech startup, which name is Legomnia. My question is, we see a very different regulatory approaches to IP in the metaverse between Europe with, for example, GDPR and AI Act, and Indians emerging frameworks. So how do you envision cross-border IP enforcement working when a French, for example, when a French luxury brand NFT is counterfeited on an Indian Web3 platform? And what legal mechanism would bridge the jurisdiction? Please. Thank you.
For whom is this question?
If I'm not mistaken, is your question about NFTs or?
Yes. Yes, my question is about, for example, a French luxury brand, NFT, is counterfeited on an Indian Web3 platform. What legal mechanism would bridge the jurisdiction?
What are the legalities behind that?
Yes.
Is what you're asking. And it's a French person is in the NFT marketplace is infringing, and how do the Indian courts deal with that? Is the question.
Yes, is the question. Thank you.
Okay. So long as it is available, if it's accessible in India and the plaintiff is from India, the principles are more or less going to be the same. So there is not going to be much of a difference. As I've already mentioned, it is the change in technology is not what matters here. Whether it's an AI platform, whether it is a digital marketplace or an e-commerce or a metaverse or Web3, irrespective of that, it is going to the legal principles behind that is more or less going to be the same. And now the courts are also giving John Doe orders and dynamic injunctions to facilitate and in the interests of the plaintiffs whose intellectual properties are being violated.
Okay, thank you so much.
So thank you, speakers, and thank you all of you for listening to us and the wonderful questions.
Thank you so much, Gauri, for moderating this session. Thank you all our panelists, Mr. Sriram, Mr. Utshab, for shedding lights on areas which feel futuristic, maybe but are already are present. So it is not that futuristic. With that, I would conclude this session, and before that, I would call on stage my colleagues. Please, Roger, please, to hand over those mementos.